quick glance notes for property law practice, bar part 2. This quick glance note on property law practice for bar part 2 is designed as a quick read material for students of property law practice in the bar part 2 program of the Council of Legal Education's Nigerian Law School. General overview and legal framework. Property law practice covers land transactions and documents, wills and administration of estates, billings and recovery of professional charges, and property law taxation. The term property refers to 1. Immovable or real property, 2. Personal or movable property, Section 201 Conveyancing Act 1881. Conveyancing refers to the creation and transfer of interest or rights in land, Section 2B Conveyancing Act, Section 201 Property and Conveyancing Law. In the course of property transactions, a lawyer is expected to advise on legal requirements, prepare legal documents and instruments of transfer, document a perfect title to land, and uphold his professional responsibility to his client in conducting transactions. Section 5 and 22, Sub 1, the Legal Practitioners Act. Various transactions affecting land in Nigeria. Transactions affecting land in Nigeria include 1. Pledge, 2. Mortgage, 3. Lease, 4. Gift of land, 5. Donation of power of attorney, 6. Sale of land, 7. Assignment, 8. Wills and assent, 9. License. These transactions are characterized by documents which serve as a medium through which interest in property is transferred. These include deeds of mortgage, assignment, lease, tenancy agreements, contract of sale of land, power of attorney, statutory forms, probate forms, letters of administration, assent, etc. The features of the above listed transactions are: lease. The landlord is the lessor while the tenant is the lessee. It must be for a period exceeding 3 years. It must have a certain commencement date and duration. There must be certainty of parties and property. The agreement must be in writing and by deed. Power of attorney. It must be in writing, must be signed, sealed, and delivered where necessary. It must state specific powers conferred on the donor. The principal is the donor and the agent is the donor. It can be revocable or irrevocable. It must contain revocable or irrevocable clauses. The power must be such the principal can exercise himself. It is not an instrument of transfer of title, but of delegation. Gift. A gift of land must be voluntary. It must be absolute. There must be an intention to make the gift. There is no consideration. There must be witnesses. It must not be in writing unless it is a formal transaction, but in order to avoid containing the gift, it has to be by deed. It is made inter vivos during the lifetime of the parties. There must be acceptance by the beneficiary. There must be delivery. A gift cannot be revoked once it is complete. 4. Pledge. The borrower is the pledger while the lender is the pledgee. It is a customary transaction, therefore it need not be in writing. The interest transferred is merely possessory. There must be consideration for the pledge and it is redeemable. Mortgage. The borrower is the mortgagor while the lender is the mortgagee. It must be by deed. It is a security transaction. There must be consideration and collateral. It could be legal or equitable. There is only a transfer of possession to the mortgagee. There must be a duration for repayment of the loan. The mortgagor has the right of redemption and it requires the governor's consent. Sale. The parties are the purchaser, assignee, and the vendor assignor. It must be in writing. There must be payment and acknowledgement of receipt of consideration. The land must be specifically delineated. There must be witnesses. It transfers absolute title in land to the purchaser. Wills. It is made by a testator to demise his property to beneficiaries. It must be in writing. It must be signed by a testator in the presence of 2 witnesses who will attest to the will. There must be testamentary capacity. It is ambulatory. It is testamentary. There must be gifts given and there must be beneficiaries. Assent. It is an instrument executed by the personal representatives of the testator to the beneficiary now to transfer titles to the demised property under a will to the beneficiary. Assignment. It is a transfer of title in land. It must be in writing and must be by deed. What is transferred is the residual interest and not the whole interest. There is no reversionary interest. There must be covenants. There must be execution. It requires the governor's consent and it must be registered. Transactions, parties, and who is responsible for the preparation of documents. For an assignment, the parties are the assignor, vendor, and assignee, purchaser. The assignee's solicitor prepares the legal document. For a contract of sale, parties are the vendor and purchaser. The vendor's solicitor prepares the legal document. For a lease, sublease license, parties are lessor, sublessor, and lessee, sublessee, and licensor, licensee. Lessor, sublessor, solicitor prepares the the legal documents. For a will, parties are the testator, executors, and beneficiaries. The testator solicitor prepares the legal document. For letters of administration, parties are the deceased and administrators. Administrator solicitor prepares the document. For a tenancy, parties are the landlord and tenant. The landlord solicitor prepares the document. For an assent, parties are the executors and beneficiaries. The executor solicitor prepares the document. Mortgage, parties are the mortgagor, borrower, and mortgagee. Lender, the mortgagee solicitor prepares the legal document. Power of attorney, parties are the donor and donee. The donor solicitor prepares the legal document. For gift of land, parties are the donor and donee. The donor solicitor prepares the legal documents. Laws applicable to land transactions, administration of estate and property taxation. In determining the applicable law to a transaction, the relevant factors to have out your mind to include: A. The nature of the transaction. B. Location of the property involved. This does not apply to administration of estate and power of attorney. C. With respect to administration of estate, wills and power of attorney, the jurisdiction covering the person making it. D. Applicable laws. E. Status of the parties. General applicable laws are Constitution of the Federal Republic of Nigeria 1999 as amended, sections 43 and 44, Land Use Act 1970, sections 15, 22 and 28, Stamp Duties Act, see sections 19 and 22, Evidence Act 2011, sections 91 to 4 and section 159, Rules of Professional Conduct 2007, Legal Practitioners Act. Jurisdiction and specific laws. Property and Conveyancing Law 1959. This is applicable to states of the old Western Nigeria. These states are Osun, Oyo, Ondo, Ogun, Ekiti, Edo, and Delta states. The Conveyancing Act 1881 and 1882. This applies to all northern and eastern states with the exclusion of Edo and Delta states. Edo and Delta states are subject to the Property and Conveyancing Law of 1959. Land Registration Law. This is applicable law in Lagos State. It places the registration of titles law of Lagos State. Transactions and specific laws. Wills Act 1837 and 1852, Administration of Estate Law of Lagos State, Literate Protection Law and Act, Land Instrument Registration Laws, Personal Income Tax Act, Law Reform Contract Law, High Court Civil Procedures of various states, Capital Gains Tax Act, Mortgage Institutions Act, Companies and Allied Matters Act, Legal Practitioners Act, Tenancy Law of Lagos State 2011, Marriage Act, Legal Practitioners Remuneration etc. Order 1991, Town Planning Laws. Ethical issues. Rule 1. Rules of professional conduct. Duty to maintain a high standard of professional conduct in all matters. Where a lawyer is found liable for professional negligence, he may be required to pay damages or refund of monetary expenses incurred as a result of wrong advice. Furthermore, he may face disciplinary action before the Legal Practitioners Disciplinary Committee (LPDC) established under Section 11 of the Legal Practitioners Act. The LPDC may give directions that he be admonished to suspend from practice, order to refund client's properties in his possession, or that his name be struck off the roll. See Olunfutu and Barclays Bank, NBA and Coco. Rule 14. Rules of professional conduct. The preparation of documents must be done diligently in line with applicable laws. A lawyer must be dedicated and devoted to the cause of the client. Rule 15. Rules of professional conduct. A lawyer must advise a client according to the applicable laws in a given situation and must only represent him within the bounds of the law. NBA and Akintoku. Rule 16. Rules of professional conduct. A lawyer must demonstrate competence and expertise in handling transactions. Failure to do so may result in liability for negligence under Section 9 of the Legal Practitioners Act. Quick glance note is powered by Rollums and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close off Idimai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 09156911367 and send your emails to rollumsandluxury@gmail.com. Instagram Rollums and Luxury, Facebook Rollums and Luxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.